The deed amendment was recorded at 9:14 Monday morning. Karen had filed her HOA complaint at 8:51. I know both times precisely because I had been watching for both. The complaint because my HOA member portal sent push notifications for any filing involving my property, and the deed recording because I had been sitting in the Garfield County Register of Deeds office since 8:15, coffee in hand, waiting for the clerk to process the paperwork I had submitted the previous Friday afternoon. The complaint arrived on my phone at 8:52. I read it while waiting. It was 3 paragraphs, organized with the specific clarity of a woman who had spent 20 years in municipal administration and knew how to write a formal document. It alleged that I had installed electrical infrastructure on my property that constituted a community amenity, and that I had subsequently restricted access to that infrastructure in a manner that violated the HOA's shared resource provisions. The deed amendment recorded at 9:14. The clerk handed me the stamped copy at 9:17. I photographed the recording stamp, sent the photograph to my attorney Leonard with a text that said, "Done." He replied in 40 seconds, perfect timing. Karen's complaint alleged that my Level 2 EV charger was community property. The deed amendment I had just recorded designated my charger, its dedicated electrical circuit, and the 6-foot easement area surrounding the equipment as a private utility installation with restricted access, formalized in the property record with the same legal permanence as any other deed restriction in Garfield County. She had filed a complaint claiming my property was public. I had responded by making it more private than it had ever been, not through argument, not through a counter-complaint, not through the HOA process she was trying to use against me, but through the one legal mechanism she could not vote away, appeal away, or complain away. The property record. What happened in the 10 weeks after that Monday morning, what Karen discovered when her attorney reviewed the deed amendment, what the HOA board found when they realized the complaint had become moot before it was 25 minutes old, what the county assessor's office confirmed when Karen's attorney called to ask whether the amendment was valid. None of that was about the charger. The charger was just the thing Karen had decided to call public. What she had not understood when she made that decision was that I had been a property rights attorney for 19 years and that my husband was a licensed electrical engineer, and that between the two of us, we had been prepared for exactly this move since the morning 3 months earlier when we first understood what she was planning. My name is Claudette Marsh, 44 years old, 19 years as a licensed property rights attorney in North Carolina, the last 8 running my own practice focusing on real property transactions, deed restrictions, easement disputes, and the legal mechanisms that govern what private property means and how its boundaries are defined and protected. My husband Ezra is a licensed electrical engineer with 20 years of experience in power distribution and energy systems. He designs electrical infrastructure professionally. He understands how systems are built, how they are measured, and how they are documented. We are, between the two of us, approximately the worst possible neighbors for Karen Aldridge Noel to have chosen to run a shared resource claim against. She did not know this when she started. She found out. We had moved to Sycamore Ridge 18 months before this story begins. A 41-home HOA outside Raleigh-established neighborhood, good infrastructure, a board that had historically been competent and fair under the presidency of a retired pharmacist named Marcus Osa, who ran meetings with the organized patience of someone who had spent 40 years managing complex inventory systems and had transferred those skills seamlessly to HOA governance. Ezra had installed the Level 2 charger in month 4. Standard process, dedicated 60-amp circuit, licensed electrician, city inspection, permit placard posted. He had also, because he is an electrical engineer who monitors systems professionally, installed a smart energy monitoring unit on the charger circuit. Every session logged, every kilowatt-hour recorded, timestamp, duration, energy transferred, cloud-backed, continuous, tamper-evident. The charger was for our Rivian. It was mounted on the exterior garage wall, accessible from the driveway, It was on our private property. It had no signage suggesting public access. It was not listed on any EV charging network. It was ours. Corinne Aldridge Noel had moved into Sycamore Ridge 8 months after us. She was 57, former assistant city manager for a mid-sized municipality, and had spent her career understanding how public resources were administered, how community infrastructure was governed, and how institutional processes could be used to establish claims that personal requests could not. She was organized, strategic, and had a gift for framing private interests as community concerns. She drove a Polestar too. She had a standard 120-volt outlet in her garage, which charged her vehicle at approximately 4 miles of range per hour. On days when she drove more than her overnight charge could replenish, she had a range problem. She had observed our charger during the installation. Our driveways were adjacent, separated by a low ornamental hedge. She had asked Ezra, during a conversation at the mailbox 6 weeks after installation, whether the charger was compatible with non-Rivian vehicles. Ezra had answered the way electrical engineers answer technical questions, comprehensively and accurately. He had explained that the charger used a standard CCS connector compatible with most North American EVs, including the Polestar, and that with the appropriate adapter, it could accommodate virtually any EV on the market. He had not said it was available for her use. He had answered a technical question about compatibility. Corinne had apparently heard something additional in that answer. She asked 1 week later whether she could use the charger on days when she had a long drive scheduled. She framed it as a neighborly accommodation. Just occasionally, just when she genuinely needed it, she would ask in advance. She would compensate us for the electricity. I was present for this conversation. I am a property rights attorney. I told her, politely and directly, that the charger was private infrastructure installed at our expense for our own use, and that we were not offering access to it. She said she understood and thanked us for considering it. I noted the conversation in the documentation record I had been keeping since month 2 of our residence in Sycamore Ridge. Because 19 years of property rights practice had given me the habit of contemporaneous documentation for any conversation involving access, use, or claims related to our property. I had not, at that point, anticipated that the documentation would become relevant in the way it became relevant. Over the following 3 months, Corinne asked the same question in 3 different forms to 3 different people. She asked Marcus Osei whether the HOA had a policy on shared EV charging infrastructure. She asked our neighbor Theodore Briggs whether he knew what our charger's capacity was. She asked a woman named Patricia Hale, who lived across the street, whether she thought the neighborhood should have a formal EV charging coordination arrangement. I know about all 3 conversations because Marcus told me about his, Theodore mentioned his over the fence, and Patricia came to our door specifically to ask whether we had heard anything about a neighborhood charging arrangement, because Corinne had described one in a way that suggested it might already be organized. It was not organized. No one had organized anything. Corinne had been building a narrative, the specific, incremental narrative construction of someone who understood how institutional processes worked and was preparing the ground for a formal claim by establishing apparent community support before the claim was filed. I had been a property rights attorney for 19 years. I recognized what she was doing. I described it to Ezra that evening. He listened with the specific attention of an engineer being briefed on a system problem. He said she's going to file an HOA complaint claiming the charger is a shared resource. Yes, I said. On what basis? She'll argue either that the installation creates a community amenity because it's visible and accessible from the common driveway area, or that the HOA's shared infrastructure provisions apply, or that she has developed a reliance interest based on what she believes our charger access policy to be. None of those are legally sound. No, but the HOA complaint process doesn't require legal soundness to cause disruption. A complaint requires a response, a board review, a meeting, potentially a vote. Even a complaint that fails wastes significant time and creates the appearance of a dispute that reasonable people might want to resolve through compromise. Meaning she might get partial access through the complaint process, even if the complaint itself has no merit. That's the mechanism, I said. File the complaint, create pressure, accept the compromise that gives you what you wanted. Ezra was quiet for a moment. He had the expression he used when he was thinking through a circuit problem, assessing the system, finding the intervention point. "What do we do?" he said. I had been thinking about this since Patricia's visit. We make the claim impossible before she files it, not by arguing against it in the HOA process, by removing the legal basis for the claim from the property record before the claim is made. How? A deed restriction, I said, recorded with the county, formally designating the charger, its circuit, and the surrounding easement area as a private utility installation with restricted access. Once that restriction is in the property record, any HOA complaint claiming community access to the charger has to overcome a recorded deed restriction that predates the complaint. Can you do that unilaterally? It's our property, the charger is our improvement. The restriction applies to our own property. We're not restricting anyone else's access to their property. We're formally documenting a restriction on how our property can be used and accessed. I paused. It's the same mechanism a homeowner uses when they record a deed restriction saying the property can only be used for residential purposes, or that no structure over a certain height can be built on a specific portion of the lot. We are recording that our charger infrastructure is private. Is this a standard? It's not common for residential charger installations because most people don't need to do it, but the legal mechanism is completely standard. He looked at me for a long time. How long to prepare? 2 weeks to draft properly, 1 week to have Leonard review it, filing same day as approval. 3 weeks. 3 weeks, I said. We need to move before she files. I drafted the deed amendment over the following 2 weeks. It was careful, comprehensive work, the kind of document that needs to be precisely right because imprecision in a deed restriction creates ambiguity that litigation exploits. The restriction designated the charging infrastructure, the dedicated circuit from panel to EVSE unit, and a 6-foot perimeter easement as a private utility installation, restricted exclusively to use by the property owners and their authorized guests. It prohibited any HOA action, rule, or resolution from requiring the property owners to provide access to the charging infrastructure without their written consent. It established that the restriction ran with the land and bound all future owners. Leonard, my supervising attorney colleague, who had been practicing property rights law for 31 years, reviewed it over 3 days. He made 4 revisions, all substantive improvements. He said, when he returned it, that it was the most precisely drafted private utility restriction he had seen for a residential property and that it was going to do exactly what I intended it to do. I filed it on a Friday afternoon. The County Register of Deeds office confirmed it would be processed and recorded the following Monday morning. On Saturday, Karen submitted her HOA complaint draft to Marcus for scheduling. Marcus, per the board's process, notified me as the subject party. The notification arrived Saturday at 6:47 p.m. I read it at dinner, then I read it to Ezra. He set down his fork. She filed Saturday. Drafted and submitted for scheduling Saturday, I said. Marcus will formally docket it Monday when the office opens. And the deed records Monday morning. At 9:14, I said, the clerk confirmed Friday afternoon. Ezra looked at me. You knew she was going to file this weekend. I knew she was going to file soon, I said. She had been building the narrative for 3 months. The conversation with Patricia was the final preparation step. She needed to establish apparent community interest before filing. I expected the filing within 2 weeks of that conversation. And you filed the restriction Friday. Friday afternoon, I said, the last business day before the weekend. He looked at the ceiling for a moment. The complaint is going to be moot when the deed records Monday. The complaint alleges the charger is a community resource, I said. The deed restriction, once recorded, formally establishes it as a private utility installation with restricted access. The board cannot take any action that overrides a recorded deed restriction. The HOA's authority is subordinate to the property record. Karen's complaint is asking the board to do something the deed restriction prohibits. Moot, he said. Before it's 25 minutes old, I said. He was quiet for a long moment. Then he said, "You've been planning this since the conversation with Patricia." "Since before that," I said. "Since the mailbox conversation where she asked about compatibility. That was the first indicator of what she was building toward." He looked at me with the expression he used when he was assessing a system that had performed correctly. Not surprised, satisfied. "Should we tell her?" he said. "No," I said. "She'll find out Monday." I was at the county office at 8:15 Monday morning. Not because I needed to be there in person, electronic recording confirmation was available, but because I had been a property rights attorney for 19 years, and there are moments when you want to hold the paper in your hand. The stamped copy was in my hand at 9:17. Karen's complaint was formally docketed by Marcus's administrative process at some point Monday morning. I do not know the exact time because the notification I received said only that the complaint had been docketed and that the board would schedule a review meeting. I sent Marcus the recorded deed amendment at 9:23 with a cover note explaining its relevance to the pending complaint. He called me at 9:41. "Claudette," he said. His voice had the specific quality of a man who has just understood something and is deciding how to characterize it. "Marcus," I said. "The deed amendment. Recorded this morning at 9:14, I said, prior to any board action on the complaint. He was quiet for a moment. The complaint asks the board to establish community access to your charger infrastructure. Yes. The deed amendment formally restricts your charger infrastructure as a private utility. Yes. And the HOA's governing documents, which I know because I have read them approximately 400 times, establish that the board cannot take any action inconsistent with a recorded deed restriction on a member's property. Yes, I said. Another pause, longer. Claudette, the complaint is moot. Yes, I said. Before the board has taken any action. Before the board has scheduled a review meeting, I said. He was quiet for a long time. I've been president of this HOA for 6 years, he said. I have never had a situation where a complaint was resolved by a deed recording before the board could docket it. I imagine not, I said. It's not a common approach. How long have you been planning this? 3 weeks of active preparation, I said, preceded by approximately 6 weeks of observation and analysis. He exhaled slowly. I need to notify Karen. That's appropriate, I said. This is going to be a difficult conversation. I imagine so, I said, but the board's position is clear. There's nothing to adjudicate. He paused one more time. You're a property rights attorney. 19 years, I said. And Ezra is an electrical engineer. 20 years. And Karen filed a complaint claiming your private electrical installation was a community resource. She did. He made a sound that was not quite a laugh and not quite a sigh. I'll call you after I speak with her. He called back at 11:07. He said the conversation with Karen had been, in his characterization, substantive. She had initially argued that the deed amendment was a retaliatory action filed in response to her complaint. He had explained that the deed amendment had been recorded at 9:14 and her complaint had been formally docketed at 9:51, based on his administrative timestamp, making the amendment 37 minutes prior to the docketing and therefore impossible to characterize as a response. She had asked whether the deed amendment could be challenged. He had told her that challenging a deed restriction required a legal proceeding, not an HOA complaint, and that the board had no authority to adjudicate deed restriction validity. She had asked whether the board could pass a resolution requiring shared EV charging access across all Sycamore Ridge properties. He had told her that the board could not pass a resolution that conflicted with a recorded deed restriction on any member's property, and that such a resolution would require a supermajority amendment to the CC and RS that would itself need to be consistent with property law. She had asked whether she could withdraw the complaint. He had said yes. She had said she would consider it. He told me he expected the complaint to be withdrawn by end of day. It was withdrawn at 3:44 Monday afternoon. I kept the notification in the documentation folder below the screenshot of the complaint filing with a note of the withdrawal time. Marcus called an HOA meeting for Thursday not to address the complaint, which was moot, but because he felt the membership deserved context for what had happened. He described it in his notice as an information session regarding recent property documentation activity affecting a member's EV charging infrastructure. 29 of 41 households attended. Marcus presented the sequence factually and without editorializing. The charger installation, the HOA's existing policy framework on private infrastructure, the complaint that had been filed, and the deed restriction that had been recorded prior to the complaint's formal docketing. He explained the legal relationship between deed restrictions and HOA authority. He explained that the board had no action to take because the deed restriction resolved the question before the board could address it. He asked if there were questions. Gerald Morrison, who lived 3 doors down and drove a plug-in hybrid, asked whether other members could protect their private infrastructure with similar deed restrictions. I stood and said yes, the mechanism was available to any property owner, and that I would be happy to speak with interested members individually if they wanted to understand the process. 4 people approached me after the meeting with questions. I answered them and gave 2 of them Leonard's contact information. Karen did not attend the meeting. Her husband Douglas attended. He sat in the back row and listened without speaking and left without approaching me. He knocked on our door Friday morning. Ezra answered because I was on a call. Douglas said he wanted to speak with me when I was available. Ezra told him I would be free in 20 minutes and invited him to come back. He came back in 18 minutes. I met him at the door. He was 61, a civil engineer who worked in transportation infrastructure. He had the specific quality of a fellow engineer, direct, unhurried. Accustomed to dealing with systems and their failures without drama. He said, "I want to understand what happened." I invited him in. We sat at the kitchen table. I walked him through the sequence, the way I would walk a client through a property matter, factually, in chronological order, without editorializing. He listened without interrupting. When I finished, he said, "She was building a case for the complaint for 3 months. Yes, and you recognized it. Yes, and you filed the deed restriction before she could file the complaint. Yes. He was quiet for a moment. I told her it was private property, he said. When she first mentioned the charger, I told her that whatever compatibility the equipment had was an engineering fact, not an access permission. Yes, I said, that's the correct interpretation of what Ezra said at the mailbox. She didn't agree. He looked at the table. She believed that accessible infrastructure has an implicit community dimension. It's how she thought about municipal resources for 20 years. Private infrastructure isn't municipal infrastructure, I said. I know, he said. She knows in the abstract, but her instinct is to see accessible infrastructure as having community dimensions. He paused. She was wrong to file the complaint. I want to be clear about that. What she was claiming wasn't hers to claim. No, I said, it wasn't. Is there anything that repairs this? I thought about this. The deed restriction stands. The property record is the property record. It doesn't go away because the underlying dispute is resolved. but that's a permanent feature of our property, not something directed at Karen or anyone else. It's a correct description of what our charger infrastructure is. And the HOA record. Marcus ran the meeting correctly. The documentation is accurate. The complaint was withdrawn. That's all in the record. I paused. What repairs things between neighbors isn't in the property record. That's a different conversation. He nodded slowly. She's embarrassed, he said. Not contrite, that's going to take longer, but embarrassed. She prepared something carefully, and it was resolved before it was 25 minutes old by something that predated it. Yes, I said. That's difficult. I imagine it is. He stood, extended his hand. Thank you for explaining it. I shook it. Thank you for coming. He left. Ezra came in from the workshop where he had been during the conversation. He had heard most of it. Embarrassed but not contrite, he said. That was his word, I said. How long to contrite? Depends on how she processes it, I said. Some people get there. Some people decide the other party is responsible for their embarrassment and harden around that. Which one do you think she'll be? I thought about Karen, her 3 months of careful preparation, her municipal administrator's instinct to see infrastructure as having community dimensions, her organized approach to a goal she had believed was legitimate. She had been wrong about what she was entitled to. She had not, in her own understanding, been acting in bad faith. She had believed the charger had a community dimension and had pursued that belief through institutional channels, the way her 20 years of experience had taught her to pursue things. I think she'll get there, I said, not quickly, but eventually. I was right, though it took longer than I had hoped. Karen came to our door herself 6 weeks after the board meeting, without Douglas, without an agenda, without the organized professional framing of someone preparing a presentation. She stood on our porch with the slightly uncertain quality of a person who has decided to do something uncomfortable and has not yet found the words. She said she had been wrong about the charger, not about her belief. She acknowledged she had genuinely believed what she believed, but about her right to pursue it the way she had pursued it. She said she understood now that she had been treating private property as though the institutional instincts of her career applied to it, and that they did not. She said she was sorry for the disruption. I accepted it because it was genuine and because 19 years of property rights law had given me a specific belief. The goal is the correct outcome, not the extended conflict. The correct outcome was the property record. The property record was permanent and correct. The conflict was over. Ezra, beside me, thanked her for coming. She left. He looked at me. That was real. Yes, I said, it was. We went back inside. The charger was running its session in the garage, the Rivian, charging at its overnight rate, the energy monitor logging every kilowatt hour. Clean data, single authorized session, exactly what we expected. I opened my documentation folder on my laptop. The complaint filing, the recording timestamp, the withdrawal notice, the board meeting minutes, Douglas's visit, Karen's apology. All dated, all timestamped, all in sequence. I added the final entry. Month 22, complaint withdrawn, board meeting documented, deed restriction permanent in property record, apology received and accepted, matter concluded. I closed the folder. The deed restriction was in the county record. The charger ran its session. The documentation was filed. A property rights attorney understands that the best outcomes are the ones that resolve correctly and permanently through the proper mechanisms, not through argument, not through conflict, but through the legal architecture that was designed exactly for this purpose. Karen had tried to use an institutional process to claim access to what was ours. I had used the property record to make what was ours permanently, unambiguously, and irrevocably ours. The legal move she had not anticipated was the one she could not undo. Everything was exactly where it was supposed to be. It always had been. Now the county record said so too.